Well, good evening, everybody. It's it's just gone 7:30 here on a Saturday night in Galashiels. But I wanted to crack on with the next part of Kathleen Zellner's motion. I've had one or two people get in touch with me. Yes, hi Mandy. I've had one or two people get in touch with me about the issue over Chris Wardman or Carl Wardman or whoever he is, the volunteer sheriff. But I think I'm going to save some of my thoughts for later on. Other than if we seriously want to avoid wrongful convictions, then surely excluding members of law enforcement from the jury has to be one of them, particularly in a case as high profile at the time that it was in Wisconsin, in Manitowoc, and you've got a Manitowoc sheriff's volunteer on the jury. I think it's it's just a no-brainer. Anyway, I wanted to crack on with the getting through the next part of the Zellner motion. So hi Mandy, hi Bean Green, and hi Colette. So here we go. Let's have a look at the next part of the motion. Here we go. And of course, here in this first line, the circuit court failed to recognize that it is axiomatic. And I had to look that word up, and I thought that is absolutely brilliant, that word axiomatic. For those of you in the UK that have watched Fawlty Towers, or for anybody elsewhere that has watched Fawlty Towers, one of my favorite episodes and one of my favorite lines is when Basil says to Sybil that you should go on Mastermind. Chosen subject, the bleeding obvious. Okay, so Zellner says, the circuit court failed to recognize that it is, and I would substitute the words bleeding obvious, that the discovery of a Brady violation subsequent to filing a motion pursuant to 97402 or 97406 constitutes a sufficient reason for failing to raise the issue in a prior motion. See State versus Allen, noting a defendant's unawareness of the legal basis of his claim may constitute a sufficient reason in satisfaction of 97406. I'll just hold it there and just make sure that everything's working quite as I want it to. Just bear with me one moment. I can't actually see the what's going on just now, so I will just make sure everything is as it should be. Okay. So let's carry on. State X-Rail versus Pollard. The defendant's unawareness of the factual basis of his claim was inextricably entwined with the legal basis of his claim. Pre-trial, the Dean and Jerry made two specific requests pursuant to statute 97123 for all exculpatory evidence and or information within the possession, knowledge, or control of the state which would tend to negate the guilt of the defendant or which would tend to affect the weight of credibility of the evidence used against the defendant, including any inconsistent statements. A second request was made by Dean and Jerry for Brady material immediately before trial on January the 18th, 2007. In July 2017, a new witness, Kevin Rahmlow, who I've had the pleasure of exchanging one or two messages with, came forward and described the most significant Brady violation in the case to that point in time. Clearly, current post-conviction counsel could not have included Mr. Rahmlow's affidavit in the June 7th, 2017 filing, since Mr. Rahmlow had not yet come forward with evidence that establishes a Brady violation. It's axiomatic. It's bleeding obvious. Mr. Rahmlow has provided an affidavit and supplemental affidavit to current post-conviction counsel. In these affidavits, Mr. Rahmlow described observing Teresa's RAV4 parked at the turnaround at State Highway 147 and the East Twin River Bridge on November the 3rd and the 4th, 2005. And can I just point out, Kevin Rahmlow is not the only one. Somebody actually got in touch with me to say they too are very, very familiar with that particular bit of land, and they too remember seeing the car parked there. What happened after that, I have no idea. I passed that information on to Kathleen Zellner, secretary, lawyer, whatever, people in charge there. And I never expected to hear anything back from them, and I haven't since. And that's absolutely fine. That's exactly as it should be. Anyway, on November the 4th, Mr. Rahmlow, Kevin Rahmlow, disclosed his observation about seeing the vehicle during a conversation with none other than Andy Colburn at the Senex station in Michigan. A wonderful station it is too. Been there a couple of times. It's great. Sells some great stuff. But immediately prior to the conversation with Andy Colburn, Kevin Rahmlow observed the missing person poster of Teresa posted on one of the doors to that particular Senex station, and recognized the vehicle on the poster as the vehicle he had seen 2 days in a row at Highway 147 and the East Twin River Bridge. On December 12th and 19th, 2016, after watching the Netflix documentary, Making a Murderer, I'm sure we're all familiar with that particular documentary, more than a year after its release, Kevin Rahmlow, who lived in Michigan, and I think I've pronounced it correctly, Michigan, sent text messages to Scott Taddick telling him that he recognized Andy Colburn from the documentary and that Colburn was the officer with whom he spoke on November the 4th, 2005 at the petrol station in Michigan. However, as we all know, Mr. Taddick never responded to Kevin Rahmlow's specific request to be put into contact with Brendan's attorneys. Did nothing. Tried to bury it. Tried to put him off. Now, Kevin Rahmlow's observation of the RAV4 on November 3rd and 4th is material to the defence theory that evidence was planted to frame Steve. It's axiomatic. If Teresa's RAV4 was spotted on the turnaround on Highway 147 on both November the 3rd and the 4th, 2005, then it must have been moved. It's axiomatic and planted on the Avery property before it was discovered on November the 5th, 2005. Clearly, again, it's axiomatic. This information supports trial defence counsel's theory that the RAV4 was planted on the Avery salvage yard on November the 5th, 2005. And that, contrary to the state's incredulous theory, it was possible to access the Avery property and plant the vehicle. Sorry, let me say that again. And that, contrary to the state's theory, which is completely way off the charts, it is indeed possible to access the Avery property and plant the vehicle. Mr. Rahmlow's testimony would have established that Steve was framed for Teresa's murder. A key issue in determining if the RAV4 was planted was the credibility of none other than Andy Colburn. At trial, he testified that he was not looking at the RAV4 when he made his dispatch call regarding the vehicle's license plate number. The state argued that Andy made his call on November the 3rd to confirm the accuracy of the RAV4 license plate number previously given to him that day, because trial defence counsel did not have a police report documenting Andy's conversation with Kevin Rahmlow. They could not impeach. Obviously, it's axiomatic. They could not impeach Andy regarding his denial. If trial defence counsel had been aware of the conversation between Andy Colburn and Kevin Rahmlow, then Kevin's testimony could have been called, then Kevin could have been called as a witness to impeach Andy Colburn. Andy would have been discredited and the jury would have been provided material information proving that the RAV4 was originally at the turnaround on Highway 147 and was subsequently planted on the Avery property. The United States Supreme Court in Weary versus Kane held Brady applies to evidence undermining witness credibility. Evidence qualifies as material when there is any reasonable likelihood it could have affected the judgment of the jury. To prevail on his Brady claim, Weary need not show that he more likely than not would have been acquitted had the new evidence been admitted. The only evidence the state presented that the RAV4 was not planted on the Avery property on the 31st, 2005 was the testimony that the 15 to 20 foot high berm prevented access to the Avery property where the RAV4 was found. However, the sweaty prize conceded the weakness of that argument when he admitted in his closing that the RAV4 couldn't be driven into that property unless somebody knew that property. The only other evidence presented by the state that the RAV4 never left the Avery property after October 31st, 2005 was Bobby Dassey's testimony that the RAV4 was still present when he left the salvage yard at 2:45. Trial defence counsel presented no evidence from witnesses that the RAV4 was planted and simply argued in the closing that there were, quote, lots of ways to get in and for someone to plant the vehicle. The failure of the state to disclose Kevin Rahmlow's interview with Sergeant Colburn is material because it would have established that the vehicle not only left the Avery property, but that it was brought back to the property and planted. If the RAV4 left the property, the state's theory that Teresa's murder occurred exclusively on Steve's property would be completely debunked. That is axiomatic. If Kevin Rahmlow's interview with Andy Colburn had been disclosed to trial defence counsel and revealed to the jury by having Kevin Rahmlow testify to impeach Sergeant Colburn, there is a reasonable probability that the result of the proceeding would have been different. A reasonable probability, quote, is a probability sufficient to undermine confidence in the outcome. Current post-conviction counsel has obtained an affidavit from a second witness, Paul Burdick, who on June 28, 2018, on June 28, 2018, who also saw the RAV4 parked at the turnaround on 147 on October the 31st, 2005. Although this witness did not report this information to the police, he does corroborate. Presumably Kevin Rahmlow's affidavit, I suspect. That must be at the bottom of the next page. No, I'm not seeing it, but anyway. No, I don't see that anywhere, but it must be there somewhere. Okay, let's carry on then. No, that's another bit that we missed, a chronology of the 30 tracks of the Manitowoc County Sheriff's Department calls to dispatch demonstrates that Sergeant Colburn's calls were made on November the 4th, 2005. Anyway, let's carry on. Let's carry on to the next bit. There must be something missing here. Anyway, not to worry. Brady violation regarding it's Joshua Radandt. The state committed a second Brady violation related to the RAV4 being planted when it failed to disclose information in a police report that the Department of Justice, the DOJ, investigators provided to Josh Radandt about its belief that the RAV4 was planted on the Avery property. Mr. Radandt has provided an affidavit to current post-conviction counsel that states the following. At that time, around November the 5th, 2005, I was told by the Department of Justice agents that they believed Teresa's vehicle was driven to the Cuss Road cul-de-sac by driving west through an empty field, then south down the gravel road past the hunting camp until reaching an intersection with the gravel road that ran northeast into the Avery property. They told me that they believed Teresa Halbach's vehicle turned northeast onto that gravel road and entered the Avery property at its southwest corner. Unsurprisingly, DOJ investigators never authored a report about the information they provided to Josh Radandt. Josh Radandt's affidavit is similar to Kevin Rahmlow's affidavit in that it directly contradicts the state's denial that the RAV4 was planted. Furthermore, Josh Radandt's affidavit contradicts the state's representation to the jury that the Avery property was inaccessible from the Radandt quarry pit. Josh Radandt could have been called as a witness to refute the state's claims that the RAV4 was not planted and to impeach the statements about the inaccessibility of the Avery property from the Radandt gravel pit. I think we'll leave it there when we've got item D to look forward, Brady violation. So thank you everybody for tuning in. So looking forward, obviously I've got quite a few questions once again for the Dr. Siltman. Hopefully we'll be able to get Millbilly to join us as well. Let me just close this down. I love this word, axiomatic. It literally means the bleeding obvious. It is so painfully obvious. It just beggars belief is another way of putting it. We'll catch you all again soon. I'm going to go and catch a couple of beers that are waiting upstairs for me. Let's just quickly run through. Bean Green, Mandy, yeah, hi Mandy, hi Jazz, and hi Shane, Colette. Mandy. Yeah, okay, I get it. There's some people that are keen to. Oh, JD, yes. JD asks, when you speak with Millbilly, can you ask to show the RAV4 on that road? I think if anything to do with the RAV4, I think Millbilly will be more than happy to discuss and show us things about it. Yeah, I don't see that being a problem. But anyway, I'm going to say cheerio. We'll catch you again soon with the next part. I'm going to say whether that's tomorrow or not, I don't know. It could well be tomorrow. Anyway, looking forward to catching you all again soon. Bye for now. Cheerio.